Morning, Justices. Francois Leroux, counsel for the first respondent municipality.
Thank you, Mr. Leroux. Mr. Krohn, the ball is in your court.
Thank you.
Francois Leroux, counsel for the first respondent municipality.
Thank you, Mr. Leroux. Mr. Krohn?
All right. Some of the pictures disappeared, but I'm then going to proceed. Let me begin by saying, Justices, that the factual matrix in this matter is not a complex one. The applicant, who I will refer to as Mr. Booi, was dismissed by the first respondent, who I will refer to as the municipality. He was, or 4 charges of misconduct were preferred against him, and he was dismissed on the basis of those 4 charges. He then referred an unfair dismissal dispute to the bargaining council. The bargaining council found that there was no substance to the charges, and whilst acknowledging that there was a strained relationship between Mr. Booi and his direct supervisor, reinstated him in the light of the fact that he had been completely exonerated. The matter then went to the Labour Court by way of a review brought by the municipality, and the Labour Court agreed with the arbitrator that, to use the words of the Labour Court, the charges were unsustainable, and what the municipality should have done, if it had addressed the matter properly, was to have dealt with the matter as a work performance issue. But the contentious point around which this appeal revolves is the circumstance that the Labour Court went further and found that the arbitrator had effectively committed a gross irregularity by not considering other factors relevant to whether or not there'd been a breakdown in the employment relationship. And the Labour Court found that, notwithstanding the fact that Mr. Booi had been completely exonerated, he, in the light of the factors which were identified by the Labour Court, he should not be reinstated, and set aside that order of reinstatement. Justices, you would have seen from the heads that we have essentially 3 broad arguments. The first is that the founding affidavits, or the founding papers, properly interpreted, the review grounds do not contemplate a ground upon which the Labour Court could have set aside the order of reinstatement as made by the arbitrator. The second ground is that it was not permissible for the court in these circumstances to have relied on grounds of intolerability when the grounds which the court relied on were not properly canvassed in the arbitration, and the employer itself did not rely on them, and they were not put to Mr. Booi. That would be the second ground. The third ground is that even if one assumes that the case was properly pleaded and the issues were properly ventilated, we submit that the reasoning of the quote unquote was wrong, and that there wasn't a basis in any event to set aside the award of reinstatement. So I'm going to deal with those 3 grounds very briefly. Before I do that, there is one point which we would seek to emphasize, and that is, if you have a look at my learned friend's heads of argument at paragraph 35, in the 3rd line, it's stated there, this is in the context of preemption, but it's stated there, put starkly but simply, Mr. Booi is an employee who sought and received payment of the better part of R1 million and proceeded to spend it. Now he wants more. So the picture is painted of a greedy employee. We submit with respect that that is an unfair descriptor. the suggestion appears to be that Mr. Booi should be grateful for the amount of compensation he got, almost R1 million. Justices, that's why we referred you and we asked the registrar to circulate the decision of Klausel versus OR Tambo Municipality. And in particular, we would refer you to paragraph 53. On the fourth line, I'll just read the sentiments expressed by Jolwana J. That matter also concerned a municipality arguing that a municipal manager should not be reinstated, but should rather claim damages. The court said the other problem with an approach that says there may be a claim for damages is that it would create a situation in which an employee could lose everything he has acquired, the home, the comfort enjoyed because of his salary, can have his children expelled from schools or places in which they are accommodated. It escapes me how a claim for damages could possibly make good such untold suffering, which would be a direct result of the termination of the contract. And then in paragraph 54, I'll just read very briefly in the third line, there are rights to dignity which employees like all citizens are entitled to enjoy. The indignity of losing everything and the damage it would cause to the very fabric of the family is unimaginable. Where it is preventable, it should be prevented. And the court goes on. Although those sentiments were expressed in the context of reinstatement of an unlawful termination, we would submit that they apply equally, particularly the references to the Constitution when one is considering a matter of this nature. Now, having said that, then I'll turn to the first leg of the argument, which is that the grounds of review did not contemplate a decision which was ultimately made by the Labour Court. The best way to do that, Justices, would be to turn to the two paragraphs which are relied upon. The first paragraph would be volume 1 at page 28. That's in the founding affidavit. Or the volume 1, page 28, and it's paragraph 52.2. There it is recorded that Booi admitted in the disciplinary proceedings that the trust relationship between himself and Ms. Mlungisi had broken down and could not seriously cannot seriously contest this at the arbitration. Now, the first difficulty and what makes this ground a red herring is that it was implicitly rejected by the Labour Court. If you look at the Labour Court's reasoning carefully, it did not say that because Mr. Booi had conceded the employment relationship had broken down, therefore that was a ground in and of itself. In fact, it recorded that is not what Mr. Booi said, but rather that he said that the relationship was strained. So we would submit that this ground in 52.2 cannot cover that laundry list of objective grounds which were ultimately relied upon by the Labour Court. The other point which we wish to make regarding this ground, and it will also apply to the other paragraph, is if the court has regard to the introductory portion of paragraph 52, you'll see in the third line, it says, it is respectfully submitted that in so doing, the panelist misdirected herself. Now, that is not a ground of review. The ground of review are set out in section 145. You can allege a gross irregularity, misconduct, arbitrator exceeding its powers, and possibly also the constitutional one, the arbitrator reached a ground which no reasonable commissioner could have reached. So we would submit that even if it was shown that the panelist misdirected herself, that's a non-starter because that's not sufficient to sustain a cause of action. And the case which we would refer the court to, one of the cases is the applicant is DERIVCO Pty Limited versus CCMA and others. It's case number D884/2012, a judgment by Gus J delivered on 17 July 2014. And we would refer the court to paragraphs 21 and 24 of that judgment. Then the second paragraph contained in the founding affidavit is found at paragraph 40, at page 40, I beg your pardon. Paragraph 5.14. This is the ground which upon which everything turns. We would submit, or the paragraph. It reads, with regard to the question of relief, Ms. Mlungisi gave evidence to the effect that the employment relationship with the first respondent was irretrievably broken down. And during cross-examination of the first respondent, he confirmed that he did not dispute that from Ms. Mlungisi's perspective, that's very important, he did not dispute that from Ms. Mlungisi's perspective, the employment relationship had broken down. In the face of this evidence, the panelist again misdirected, which is not a ground of review, himself in ordering the first respondent to be reinstated. We would submit that if you look at that paragraph in its true context, all that paragraph says is that the arbitrator erred because he did not take into account the fact that Ms. Mlungisi, that Mr. Booi could not dispute Ms. Mlungisi's contention that the employment relationship had broken down. We would submit that that paragraph goes no further than that. To suggest that that paragraph should be read to include or read in effect to the following effect, that leaving aside the views of Ms. Mlungisi, there were a number of objective grounds which clearly showed the employment relationship had been broken down. These were, for example, a secret telephone recording, etc., etc. As we've said in our head, context is everything, particularly when you're going to rely on a ground to argue that an employee should lose his job. We submit that more is required if one looks at Rule 7A2C, which says that the applicant must set out the factual basis. And lastly, we would submit under this heading that the proof is in the pudding. If that had really been what was envisaged, then it would have been argued on that basis. But we know that when counsel for the applicant argued the matter, he argued it in line with paragraph 5.14. In other words, that the test was subjective, and he did not argue on a basis which could in any way have given rise to the judgment. And lastly, under this heading, we would say that what the municipality has done in its heads of argument is to refer to various passages in the oral address as well as in the judgment with a view to trying to ask the court to interpret these grounds through those lenses. But we would submit that what was argued in the sense of what questions Mr. Booi, the court put to Mr. Booi, that's not relevant to determining what the grounds of review were. And those would be our submissions on the first leg of the argument.
Mr. Kroon, your 10 minutes protection time has expired.
Yes. Thank you. Thank you, Acting Deputy Chief Justice.
Mr. Kroon, if I may just come in there. Even if you are correct that the Labour Court raised the issue regarding the intolerability of a continued employment relationship, mero motu, is it not so that the court would have been obliged to interrogate whether or not a continued employment relationship would be tolerable before it could make a finding on the arbitrator's remedy of reinstatement?
We would submit not, and that almost brings us to the second leg of the argument, because in order to make that finding, the court is going to have to canvass the evidence, almost conduct a hearing, which it effectively did when the matter was argued. So it's almost impossible for a court to make a finding in this regard. We would say for two reasons. Firstly, there's the danger that the court may rely on an objective reasoning or an objective reason which it thinks is a valid reason, but for example, the employer has no problem with that at all. And the effect of that would be that the court is making its own, or substituting its own subjective view for that of the employer. The other problem we would submit is that it's unfair, because an employee only gets one chance at the arbitration. And if he's sort of ambushed, as it were, in a review application in respect of issues which were not properly canvassed and not put to him, then we would submit that that would be grossly unfair. We submit that the point is different. It's not a legal point. That's the problem. It's not like jurisdiction. It's something which can only be decided with reference to the evidence. And if arguments are relied upon which were not relied upon at the arbitration, that goes against the rules of natural justice and the employer's right to a fair hearing. But perhaps I could illustrate that pertinently in submission when it comes to the allegation made and relied upon and ultimately found by the court, which was to the effect that Ms. Mlungisi had testified that she was embarrassed and humiliated and disrespected by Mr. Booi. If I can ask the court to see how that was actually canvassed in the arbitration hearing, to turn to volume 3, page 147. That would be 147 of the numbering and 150 of the actual number on the transcript. I apologize for the confusion there. Acting Deputy Chief Justice, then, if you have regard to line 6, Mr. Booi says, "I think, Director, you have said that I'm verbally abusing you in meetings, and I'm putting you that you have said this is not true. Sorry, I'm putting to you that what you have said is not true. In actual fact, it is you who is always verbally abusing me in meetings, and that is why I decided to record these meetings, and I have a lot of some clips to prove that, but I've selected one. Do you agree what you said is not true, that I'm verbally abusing you in the meetings?" Ms. Mlungisi, "I won't agree." Mr. Booi, "You don't agree, so I must play the sound clip." And then she says, "You can." "Okay, I will play the sound clip." And then Ms. Mlungisi says, "But I want to know, Commissioner, what is the relevance of that in this hearing? Because we are looking at these charges." So it's the municipality, and the Commissioner accepts the objection. The municipality objects to Mr. Booi wanting to ventilate this issue, which ultimately formed a very important and crucial part of the Labour Court judgment. It would be grossly unfair to say to Mr. Booi, well, as the court effectively did, it gave no reason, but it said, "We believe Ms. Mlungisi." This is the lady who was proven to have attempted to mislead the arbitrator when it came to the content of the meeting. And it's difficult to understand with respect as to how the court came to that conclusion, but there is a clue as to how the court accepted the version of Ms. Mlungisi. If the court turns to my learned friend's heads of argument at page 18. It's easier for reference, but at the bottom of page 18, the court reveals its reasoning in this quotation. It says, "It is not objectively said that is it not objectively said that a relationship with the trust and confidence is broken down?" I'm saying, does it not matter whose fault it is? It may well have been anybody's fault. I accept that. We submit that that is the wrong approach. It's inconsistent with the Crocombe decision. Whoever was responsible for the damage to the relationship, that is obviously a highly relevant factor. But the court appears to have assumed on this reasoning that then, whatever Ms. Mlungisi, whose credibility had been damaged, says that must be accepted. Those are dangers. Perhaps I could illustrate one more before I move on to the next leg. If the court could turn to volume 3, page 83. Justice, you'll recall that in the judgment, where one of the factors ultimately relied upon by the court was that Mr. Booi was a senior manager and he had a poor work performance record. Now if one goes to line 10, it reads there, Mr. Booi, yeah, but I must just entertain that. Let's look at the transcripts because the charge is about insubordination. It is not about performance. And then this should be the representative of the municipality replies. So why would you waste our time? In other words, and the court can read as the transcript goes on. When Mr. Booi wanted to address the question of performance, the response from the representative of the municipality, but you're wasting our time because that's got nothing to do with the charges. But now the municipality wants to defend the judgment on the finding of poor work performance. We submit that is grossly unfair. If that is par excellence a case of an issue which was not ventilated, and for that reason it was not open to the court to make such definitive findings as it did on the matter.
Mr. Kroon, I'm sorry, but that issue would have no bearing on the question of the intolerability of the relationship. As I understand, the Labour Court did not interfere with the findings of the arbitrator on, for lack of a better word, conviction or finding him guilty, or finding him not guilty, rather. What the Labour Court intervened on the basis was, while there was proof that the relationship between the employee and the employer, or the supervisor of the employer, had broken down irretrievably, and therefore, under section 193(2) of the LRA, reinstatement was not appropriate. So the point that you're making now is not relevant to that inquiry, is it?
Well, my understanding is, and that the court did rely on that as one of the grounds as to saying as to why Mr. Booi should not be reinstated. Another ground was, for example, allegations that he had, and this also goes to his conduct, that he had disrespected and humiliated Ms. Mlungisi. Now, though he was never charged in that respect, so that is why we've referred to the Fijian case as well as the Extrata case. But my understanding is the court said that this was a senior manager, and he hadn't performed well, and that was one of the factors that was taken into account.
No, but wouldn't that be wrong? Because what has that to do with the work relationship that has broken down irretrievably? If an employee doesn't perform, that's a different issue altogether. It doesn't go to the intolerability of the relationship. I understand the contention that the relations between him and Mr. Mlungisi had broken down, and you have argued that there's no proof of that, and therefore the Labour Court misdirected itself. That I understand. The question that I was raising is, should we spend time on whether or not Mr. Booi was guilty of poor performance? Because that has nothing to do with intolerability.
I agree wholeheartedly, and that's what the Labour Appeal Court said in the ex parte case, is that if there was another ground for the dismissal, then he must be reinstated and you must follow the correct processes. And that's perhaps one of our main submissions, yes.
Okay, thank you.
Mr. Kroon, do you agree that the Labour Court's reasoning as to the breakdown of the trust relationship is largely confined to the evidence that was led in respect of the main charges?
I wonder if I can ask you, please, Acting Deputy Chief Justice, to repeat that.
Yes. Do you agree that the Labour Court's reasoning as to the breakdown of the trust relationship is largely confined to the evidence that was led in respect of the main charges?
If I heard you correctly, you said it is confined, or it's not. Should not be confined.
It is confined.
Yes, that is a very trite principle. The reasoning is that if you are assessing the reasonableness of the decision maker, then it's with reference to the evidentiary material before him. It's unfair to raise things and ask questions of a litigant during oral argument, as what happened in this matter. So yes.
Mr. Kroon, at para 20 of the judgment of the Labour Court, in fact, para 20 and 21, the Labour Court sets out the basis for coming to the conclusion that the relationship between the two parties had become intolerable. The first one is the reliance on the evidence of Ms. Mniki. And then the second one, he says at para 20, under cross-examination, while the employee contended that he would be able to work with Mniki again, he considered that they had a challenging relationship and that the relationship was sour. And then at para 21, he says, one of the listed factors in section 193.2 in the form of intolerability of a continued employment relationship was clearly established by the evidence. The applicant's evidence was that the prospect of any working relationship between the employee and his supervisor, particularly, and the senior management of the applicant more broadly was remote, if it existed at all. And then the last part, he deals with the recording, which was done by the applicant, where he says, where the trust and confidence had been eroded to the point where the employee clandestinely recorded meetings between him and his superiors, and clearly spent a substantial part of his working time concerned with what he perceived to be conspiracies against him. And those were the basis on which he found that the working relationship between the two parties was intolerable. Is there anything wrong with how he dealt with the matter? And thereafter, he then says there is no need for referring the matter back to the arbitrator for reconsideration, and then makes the finding that the best outcome would be compensation to the applicant.
If I can try and deal with the factors that were raised individually, you mentioned that he'd said that the applicant, that Mr. Booi spent a considerable time of his working time on conspiracy theories. I don't have it in front of me, but in my heads, I did refer to the portion in the transcript where we said that when this issue was raised, it was the municipality itself that said it's not relevant to the charges, so it wasn't ventilated. That's the one point. The other point is of course that if he wasn't working and he was guilty of dereliction of duties, then he should have been charged. But and we sound like a stuck record, but going back to the Fijian case and the Fidelity cash management case, it's not permissible for an employer to rely on conduct which was not relied on as the basis for the dismissal. It can't be that when the charges fall flat, an employer, as it were, has a second bite of the cherry and can see, well, what else did you do whilst you were in our employ, and then try and hold that against you. The other ground is the telephone recordings. We've tried to emphasize in our heads that this is a matter where context is everything. Mr. Booi had a suspicion that his employer would mislead people, and as it turns out, the arbitrator as to what occurred at the meeting, his suspicion turned out to be well-founded, and for that reason, he was able to defeat one of the charges. Yet that very act is held against him. My learned friend has referred to the Geertz case. I think there the dismissal must have occurred almost a quarter of a century ago. But the not only have times changed, in the Geertz case, the facts were worlds apart. There you had an employee who was not party to a meeting. It had nothing to do with the employee's performance. The employee planted a dictaphone in a private meeting. That was unlawful. It was an invasion of a privacy. She then lied about it. That's completely different to an employee who has a basis for protecting himself because he's worried about his job security. He then makes a recording, and we submit that the court then erred. The court didn't see in that act in its proper context. It simply said to Mr. Booi in accusatory vein, as we say in our heads, what type of employee does that? We submit that wasn't the time and the place for a hearing on that. So we've tried in our heads to I think other than performance, there were 4 grounds, and we've tried to set out exactly the bases as to where the court fell short in those grounds.
Mr. Kroon, correct me if I'm wrong. The way I understand the matter, the Labour Court, what it did was to consider the record, which was before the arbitrator. He agreed with the arbitrator that the misconduct charges had not been proved. Therefore, the applicant was found not guilty. Then it then relied on section, and it was obliged to do so, section 193, which says that the court must require the employer to reinstate or re-employ the employee unless A, B, C, or D. And the relevant one here is B. And then what the court did when it to determine whether those circumstances were present was to have regard to the evidence. Are you saying the Labour Court was wrong in doing so, or what?
Yes, we are, and at the risk of sounding like a stuck record, there's 2 principal reasons. One is really a procedural one, and that we've tried to elaborate on the heads, is that these allegations which were relied upon were not properly ventilated. They were not relied upon by the employer. We've tried to give the example of the allegation of Mr. Booi having insulted or been rude to Ms. Mlungisi as a result of an objection from the municipality. That was not ventilated. The other danger is that if these facts, when you say the evidence before the arbitrator, the evidence would include the employer's view of these acts of misconduct or undesirable acts. But unless the employer then leads evidence, that's the evidence that's missing, or it's put to Mr. Booi so that he has a fair opportunity to say, no, that wouldn't have affected the employment relationship for this and this and this reason. I think it's even in the case of the Mediterranean case relied on by my learned friend. The court acknowledges that this is a tricky situation because it can mean that there can be applications for further evidence to be led at a later stage. And I suppose that's the quandary facing the court is when can a court, even if the employer has not relied on it, then decide that there's certain facts here that even if they were not relied on by the employer, I can decide that they rendered the employment relationship intolerable, and that's the main issue. And we would submit that a court should be very reluctant, particularly where the employer hasn't relied on the grounds, because it may be that the employer didn't view whatever grounds the court thought subjectively rendered the employment relationship intolerable.
So what should have been, what should the Labour Court have done? Would it have been a question of remitting to the arbitrator to consider what is set out in 193.2, or order a reinstatement of the applicant because he had not been found guilty?
Well, we submit that if this was the case, the employer was ultimately going to rely on, then it should have made it at the arbitration level. So once the grounds pursued to the effect that the arbitrator had erred in finding that Mr. Booi was not guilty of misconduct, once those grounds failed, he should simply, with respect, he should simply have dismissed the application because there wasn't a basis for him to make the finding, which he did, and it was open to the employer at the arbitration stage to have made its case. That would be our submission. I don't know of any precedent where, if it was referred back when an arbitrator is, well, he's pretty much made up his mind, I suppose, but that I would leave that in the court's discretion.
Thank you.
Can I just ask you,
If my sister is finished, can I just take you back on one aspect, Mr. Kroon? At paragraph 22 of the Labour Court judgment, the learned judge seems to be making a very serious finding that the applicant ought properly to have instituted proceedings to address the employee's inability to achieve acquired performance targets. He did not do so and acted precipitately by seeking to charge him for misconduct on grounds that were simply never sustainable. The idea I get here is that this could have been, well, perhaps for lack of a better word, a fishing expedition. The employer knew that if a correct procedure was followed of performance-related inquiry, and where a code of conduct would have been followed, and where issues relating to including performance relationships would have been addressed differently, chose to take the route of misconduct on charges that were from the beginning not sustainable, and later seek to find a reason and not to reinstate the employee. Isn't that what I get? And you seem to have raised this point also in your heads of argument.
Yes, and that is precisely the point which I think it was Murphy J.A. so resoundingly tried to make in the Arbitrator case when he endorsed the decision of the Labour Appeal Court, in effect to say, you can't dismiss someone for poor work performance under the guise of misconduct. And that's what's happened here. That as soon as the court made that finding, our submission is the review application should have been dismissed on that basis alone.
So all these issues would not have arisen, especially the intolerability of the relationship. Everything should have ended there because now it's on a different guise, as I see it. You have muted yourself, we can't hear you.
Yeah, the court can't, maybe I'm approaching it from a different angle, but it's not possible for a court to speculate as to what would have happened had they followed the correct procedure. But there's no reason to think that if they had followed the correct procedure, there is mentioned somewhere in the evidence there was a poor work performance code then, and they'd put Mr. Booi on terms, they'd given him an opportunity to improve, he would still be working there. And that is the grave injustice we submit that has been occurred here.
Thank you.
Mr. Kroon, I'd like to just deal with the question that I see is the crux of the matter, and that is the question of this intolerability of continued employment relationship. You've referred us to paragraph 5.14 at page 40 of the founding affidavit. Now there in the last sentence, the deponent says, in the face of this evidence by Ms. Mlungisi and the respondents and Mr. Boi's reply, the panelist misdirected himself in ordering the first respondent to be reinstated by the municipality, rendering the arbitration award liable to be reviewed and set aside. Now, I take your point that you say that that this is not a proper ground of review, but leaving that aside, doesn't the municipality pertinently raise the point of reinstatement there? And then this is replied to at page 54 of that same volume in the answering affidavit at paragraph 13.3. There, Mr. Booi pertinently deals with it. And as I understand it in the oral argument, in the transcript of the oral argument, the party specifically addressed this point. So can it be said that the court raised it mero motu? It seemed to me to have to be ventilated on the papers, albeit inadequately according to you. And it was also pertinently argued during oral argument before the Labour Court, this very point. So the court didn't raise it mero motu on the face of it, or am I wrong?
I may be wrong, but my understanding of the transcript is that when the matter was argued, none of the points, not even one that was ultimately found their way into the judgment was relied upon by the municipality when the matter was argued. It was only the court who mero motu raised, I think, primarily the point of the clandestine recording, but the other points which ultimately found their way into the judgment were not even raised with Mr. Booi. That would be the one submission. As I submitted earlier, we submit it's too late to raise something in argument that's not in the founding papers, and we would submit further that the municipality shouldn't rely on Mr. Boi's answer in his answering affidavit as a lifeline. The paragraph should have been a self-standing paragraph containing the ground. And as we said, if one looks at the context, what the ground should have read is, irrespective of the views of Ms. Mlungisi, there were a number of objective grounds that rendered the employment relationship intolerable. These were, and then you could have listed them. That would have been the way to plead that ground. I can take it no further than that.
Well, it seems to me at page 54 of volume 1, the portion I'd referred you to, paragraph 13, Mr. Booi pertinently says, when he answers the averments in the founding affidavit, he says at paragraph 51 to 52 of the founding affidavit, and then importantly he says, and paragraph 5.14 of the supplementary affidavit, which is the part I read out to you. And then he deals with it. He pertinently answers that, so it is in the papers. And secondly, let me first pause there. There's a second aspect in the judgment itself, but what do you say about those portions of the affidavit? He pertinently answers something that was said, that was averred in the founding affidavit.
Well, I can take it no further than firstly to repeat that the ground must be in the founding affidavit. It can't be supplemented by what's contained in the answering affidavit. And then I don't think I know he talks about the allegations of being insulted and that, but I'm not sure that he deals with all the grounds that were ultimately relied upon. I can take it no further than that.
All right, lastly, let me just then refer you to page 60 of volume 1. This is a judgment of Aniker J, where he is in the labor court dealing with the grounds of review. Paragraph 13, page 60, and he says, I'm reading from the record, paragraph 13. The applicant has raised 3 primary grounds for review. He lists the first 2, but I'm interested in the last one. Right towards the end of paragraph 13, the learned judge says, thirdly, the applicant submits that the arbitrator, having ordered the employee to be reinstated, in spite of the fact that the trust relationship between him and his employer had irretrievably broken down, committed a reviewable irregularity, end quote. So what the learned judge is doing there is summarizing the 3 primary grounds for review. And thirdly, he says this was pertinently raised as a ground for of review. So there it is. It was before him, properly pleaded and properly considered. How could it be said he raised it mero motu?
Well, two points. The first is we're not disputing, and I want to make it clear that the issue of the trust relationship was raised. But if you look at that, the paragraph in its true context, what it says is no more than this. When Ms. Mlungisi testified that the employment relationship had broken down, Mr. Booi answered that he could not dispute that. Now, that is something with respect that's completely different to what ultimately found itself in the judgment. And then just one small thing, which without wanting to hammer on the point, the learned judge says that there was an allegation of a reviewable irregularity. That's not correct. There was only an allegation of a misdirection, but I've made my submission there.
Thank you.
Mr. Kroon, with regard to the issue of the intolerability of the working relationship, what I have found striking is that the Labour Court relied on the evidence of Ms. Mlungisi, whose complaints of insubordination, dishonesty, gross negligence, and putting the municipality into dispute were found to be unmeritorious, even by the Labour Court itself. What do you have to say to that? You are muted, Mr. Kroon. You are muted.
I beg your pardon. Ms. Mlungisi's credibility was seriously damaged. That's the one point, as you correctly pointed out. And the other point is that when Mr. Booi wanted to demonstrate...
Mr. Kroon, sorry to interrupt you. How was it damaged?
When she gave the evidence of raised voices at the meeting, what happened is Mr. Booi then played the recording, and she had to retract that. So she'd misrepresented what had occurred at the meeting. And then the other point is that when Mr. Booi, I've referred to it earlier in argument, when he wanted to demonstrate that actually it was Ms. Mlungisi who was abusing him, the court can have a look at the transcript, but the bottom line is he was prevented from leading that evidence by way of another recording.
Yes, you see, the court gave weight to her views of the applicant's competence, her feelings of humiliation, embarrassment, and disrespect at his instance, and her assessment of the intolerability of the working relationship. Was it surprising that Ms. Mlungisi would lead this evidence, which reflected poorly on the prospects of a continued relationship between him and the applicant?
Well, it seems to me that her evidence has almost two dimensions to it, if one looks at the different parts in the transcript. On the one hand, and we submit that this was the thrust of her evidence, we quoted in our heads, she said, because he hasn't shown any remorse for the conduct that he was guilty of in respect of the charges, that is why I believe the trust relationship has broken down. But that obviously falls away once it's shown that the foundation for those perceptions is without any basis. Then the other point is she seems to talk about previous meetings where she was disrespected and or even undermined or insulted. And we cannot emphasize this more. If that was the case, then Mr. Booi should have been charged for those allegations of misconduct at whatever meeting to say, this is Mr. Booi, you're guilty of insubordination. But applying the Fijian case and the Fidelity Cash Management case, it's not permissible for an employer to rely on those grounds.
Let's go to the arbitration award, Mr. Kroon. It's in the bundle that you've given to the court. What I want to know is whether it was unreasonable for the arbitrator to conclude that Mr. Mlungisi's views, while revealing a fraught relationship with the applicant, did not reach the high bar of intolerability that would warrant a departure from the primary remedy of reinstatement. If we have regard to his remarks, which are at para 18 of the award.
Well, we would submit that even if you disagreed with those views, that they are certainly not views which no reasonable arbitrator could have come to. The wind was taken out of the sails of the municipality when they couldn't prove the charges. Ms. Mlungisi had testified, he'd shown no remorse in respect of the charges. And then the other factors relied upon, we submit we're not permissible to rely upon for all the reasons in the heads. And we would go one step further towards the end of our heads. We refer to the Rawlins case where the SCA said that, you know, if you're two high-level employees, even if there's a perceived breach of a trust, you should be able to sit down maturely and constructively and just work out of your differences. But because one employee is very upset with another employee, even if they're reasonable grounds, maybe the attitude is wrong, that's not sufficient for an employee to lose his job.
And lastly, Mr. Kroon, what should we make of the Labour Court's finding that the relationship of trust had deteriorated to a point where the applicant was secretly recording meetings between him and his superiors? Why does this not establish that a continued employment relationship is intolerable?
Well, we've tried to, as best as we are able, and we've referred to the one English case, which, with respect in a very enlightened manner, sets out the circumstances in where an employee may be justified in making a recording. And one of those circumstances, if he's there to protect his job security. And that was fundamentally why Mr. Booi says he made the recordings and he was proved right. I would add that these are not highly confidential meetings. If there's a meeting about one's performance, one could have taken notes. It's just one step away to push a button on a cell phone, as that case says. We would submit that maybe on reflection, Mr. Booi could have said, I just want to place on record, I'm recording this meeting, but no one could have stopped him. He was perfectly entitled to record it. But then, of course, if he'd done that, he wouldn't have been able to expose his employer as for what it was doing to him.
Mr. Kroon, can I get clarification on this point? It seems to me that the employer relied on what Section 1932 says. Leave aside for a moment the question whether or not there's adequate proof that the relationship had broken down to the extent that reinstatement should not have been ordered. It seems strange to me that where all charges of misconduct have been found to be unsustainable, that the employer can still persist in getting rid of the employee on the basis of section 1932. Was the section intended to apply to circumstances where the employee has been exonerated of all charges of misconduct? You are muted again, Mr. Kroon.
My apologies, Justice Shafter. We would submit that section was more intended for a circumstance, say for example, where there was an inconsistency challenge, and the employee was found guilty of very serious misconduct, but his dismissal was held to be substantively unfair. In that circumstances where the employees, as it were, got blood on his hands, yes, you can penalize him, as well as in the well-known SARS case, where the employee had acted, Ms. Kruger had acted egregiously. There you can penalize him. But when I might just make this comment in passing, Mr. Booi only got 2 months more compensation than Mr. Kruger, who was shown to be an egregious racist. And that just, with respect, it does offend one's sense of justice, that if an employer has made up his mind, you're not coming back, and can trample on an employee's right to job security, we would submit the court to take a narrow approach to the interpretation of that section.
If the bases for dismissal are all set aside, they are found to be wanting, can we still speak of a dismissal that was substantively unfair, where there was no reason at all to dismiss in the eyes of the law? In other words, if the termination of a contract is unlawful, you and I know that the law does not regard that termination to be termination because it was done against the law. So if Mr. Booi had brought a cause of action based on the common law, we wouldn't be debating this at all. But he brought a cause of action based on the LRA. Now, I want to know whether the LRA in the relevant provision contemplates dismissals which do not exist in law. Because my understanding is that the LRA is focused on the fairness or unfairness of dismissals which exist in law. Now, this one, can we say it's a dismissal that exists in law when all charges, the employee is cleared of all charges, which indicates that the employer was on the wrong. The employer all along wanted to get rid of the employee. He fails on the basis of the grounds that it had put forward. But we say in law, that employer could still succeed in getting rid of the employee because section 193 sub 2 says, if the relationship was intolerable, then the employee should be dismissed. And the only thing that they can get is compensation. That is my gravest concern as to how the Labour Court has applied section 193 sub 2 in the circumstances present.
Justice Jafta, I would say, I'm not sure how to put it from a purist point of view, but what has occurred in this matter is as close as you can get to an unlawful dismissal, which is deemed not to have existed. And I would also say that there must surely be an irony where a core value of the Labour Relations Act is job security. And the whole reason labour law developed was, one of the main reasons was to protect employees against baseless dismissals. Yet by this distorted application of a provision in the LLA, the employees got less protection than he would have at the common law. We would submit there's something wrong there.
Yes, thank you.
Justices, I did indicate to Acting Deputy Justice Kampepe that my junior was going to argue the points of condonation and preemption, but I see that I have taken a lot more than the 45 minutes here.
Mr.
Yes.
Kran? Mr. Kran?
Yes.
Can you hear
I'm
me?
listening.
Yeah. I'm looking at section 192.3 and taking up the point from my brother Jafta. The text is that the Labour Court or the arbitrator must, the word must, not may, require the employer to reinstate. And those are the 4 conditions for the exception. Now, must means that the default position for any unfair labor practice award must be reinstatement unless there's an irretrievable breakdown, which is what we are busy with here. Yes? So the basis that the Labour Court found that there was an irretrievable breakdown, and it was invited by the 3rd ground, as my brother Majid pointed out at paragraph 3, to look into the irretrievable breakdown. But the basis for its decision appears at page 20, and there's a lengthy paragraph in which one sentence is devoted to the position of the applicant. And that's the fundamental basis of this decision. What you're saying when you take on or challenge, I think it was your 3rd ground, that the arbitrator had no business, that the Labour Court had no business to look into the arbitrator's award as being a misdirection or an irregularity, because that was a finding of fact based on the evidence before the arbitrator. And findings of fact are not reviewable by a Labour Court unless they are findings that no reasonable arbitrator could make. And you're saying that this, based on the evidence before the arbitrator, that was an entirely reasonable judgment decision.
Yes, an entirely unreasonable decision. And as the acting Deputy Justice Kampepe pointed out, it seems to be that the central plank of that decision was the evidence given by Ms. Mlungisi, and there's no basis. I can find no basis in the judgment as to why he preferred that evidence and why he found that the arbitrator had to put it colloquially, gone off the rails. Yeah.
Sorry, let me interrupt you. What I was saying is that the evidence before the arbitrator justifies the arbitrator's finding implied in the reinstatement award that the relationship had not broken down irretrievably.
Yes, we would submit that that's correct. And in fact, the arbitrator was honest and he was transparent. He made no bones about the fact that there were tensions, but there's that's
a she. The arbitrator is a she.
I beg your pardon for that sexist assumption. The arbitrator made no bones about the fact that there was some tension in the relationship. So that would demonstrate that she was applying her mind, and but that is a far cry from making such a prejudicial and far-reaching finding that Mr. Booi should lose his job.
And that finding was based on findings of credibility. And in any event, it takes two to break a relationship or make one.
Quite correct, yes.
And on the evidence, that seems to be a situation which required much more probing to find fault on either one or other party.
And who knows if they had followed the correct procedure, that this would, in other words, addressed it as a work performance issue, that this would not have come out in the wash, and that even if there was a mediator, these issues could have been resolved. But it seems like it's difficult not to get the impression that the court did take the side of the municipality and Ms. Mlungisi.
Thank you.
Thank you, Mr. Kroon.
Justices, can I ask my junior to come and touch on the questions of condonation and preemption?
Yes, you may.
He's going to be using this computer, so I'll be exiting.
Yes. Thank you, Mr. Grobler. You may commence.
Thank you, Acting Deputy Chief Justice. Justices, I'm addressing the aspects of condonation and preemption. In particular, with respect to the condonation aspect, there are three main points I want to touch on. The first point relates to the lack of any opposing papers filed in this matter, besides the argument that was filed subsequent to the direction. In this, the rules of the Constitutional Court say that when an application for leave to appeal is filed, the respondent may file opposing papers which set out the grounds for such opposition. No such response was filed by the respondents at all, no answering affidavit or notice. So at the outset, I must remark that it's unclear at this point what the basis for the opposition to the condonation application is. And in light of the fact that there's no responding papers, I submit that effectively this condonation stands unopposed. The next aspect I wanted to touch on was the reasonable explanation submitted by the applicant. Now, the extent of the delay in this matter is admittedly extensive. It's 213 calendar days. The delay is set out in greater detail in the submissions, but it's submitted that the applicant does submit a reasonable explanation for this delay. The explanation is divided into the applicant's lack of funds to fund legal assistance, his own lack of legal knowledge, the interference of the year-end period in his ability to file the application for leave to appeal, and then the subsequent impact of the COVID-19 pandemic. It's submitted that although this delay is extensive, that this explanation does is reasonable. However, Justices, insofar as the delay may be inadequate, it is submitted that this matter has excellent prospects of success, and they salvaged such inadequacies. In this regard, this Honourable Court is referred to the argument on the main merits that you just heard. The third point that I want to touch on is that if the explanation is unreasonable, condemnation ought to be granted, notwithstanding this, owing to the importance of the issue at hand. This court has a discretion to overlook a delay when the impugned, even if it's extensive, where the impugned decision concerns the breach of a constitutional right. The constitutional right in question in this matter is the right to fair labour practices, which has at its core value the right to job security. This principle regarding the court's discretion to overlook such delays was set out in Notwaya versus Makana Municipality and others, which was a 2019 Constitutional Court decision. This value of job security, I must emphasize, is particularly important in light of the prevailing COVID pandemic. In the circumstances, it's submitted that this court ought to grant condemnation for the delay. I'm now going to move on to the arguments in regards to preemption, unless there's any questions on the condemnation aspect.
On the condemnation aspect, Mr. Grobler, this court received submissions from the applicant on the 30th of April, when he was directed to file written submissions by the 21st of January, 2021. There is no explanation given for the delay in the filing of his written submissions. What is this court to make of that?
My acting Deputy Chief Justice, the applicant, if I heard you correctly, that was at the point where the applicant was still representing himself and had no legal assistance. Is that correct? Was that dated in April?
Yes.
January. Yes. The applicant had no legal assistance due to not having any finance available to fund an attorney or representative. I can take it no further than that. Unfortunately, the applicant simply couldn't comply with the rules due to him being a layman at the time.
But that time period was not taken care of when you were applying for condonation and in your written submissions on condonation.
Yes, my lady, my Honourable Acting Deputy Chief Justice, that time period, you're correct. I didn't deal with them that time period in the submissions on condonation. Insofar as I can make submissions now from the bar on that aspect, I can simply say that the applicant was unrepresented at that stage and had no assistance. His failure to timeously submit the heads of argument can only be attributed to that. All right, I'm going to move on to the submissions on preemption, unless there's any more questions on the condonation aspect. The applicant, in this matter, it's first, I want to first point out that the first point, there are 3 points essentially that in respect of preemption that I want to address. The first point is that it's unnecessary for the Labour Court, it was unnecessary for the Labour Court to have made a final pronouncement on preemption. In the Labour Court ruling that dismissed leave to appeal, the Labour Court dismissed the application by ruling that there was no condonation granted for the leave to appeal. It based this on 2 principal reasons. You can find this in the last supplementary bundle submitted on page 51 and paragraph 7 of the Labour Court's ruling on the leave to appeal application. The Labour Court rules as follows. It follows that in the absence of an acceptable explanation for the delay in the filing of the main application and in the absence of any prospects of success in that application, it's referring to the application for leave to appeal here, the application for condonation stands to be dismissed. Accordingly, the Labour Court dismissed the condonation application, and it wasn't necessary for it to pronounce finally on the preemption issue at all. So insofar as preemption is concerned, it was only discussed in the consideration of prospects of success. Prospects of success merely implies a determination of the likelihood or chance of success when the main case is heard. It's not a final decision in respect of any of the issues, like in this case, preemption. There was no final decision in respect of preemption. The authority for that can be found in the matter of Premier Valves Pty Limited versus McKee, JS 491/18 of 2020. It's ZALC JHB 127 at paragraph 20. Accordingly, the issue of preemption was not finally decided. The practical impact of this on this case means that the issue of preemption needs to have been raised by the respondent in opposition to the Constitutional Court application. That is because preemption, as was said in SARS v CCMA, is essentially the waiver of the right to appeal. Like any waiver needs to be pleaded. There is very trite authority on this principle. The matter of Dabner versus South African Railway Harbours, the 1920 AD 583, also held that the onus in preemption is on the party alleging it. In Collin v. Rietfontein Engineering Works, 1948, SA 413, the appellate division held that it's necessary for party relying on waiver to plead such waiver. The same in Montes Township and Investment Corporation and another v. Gous, 1965 for SA 373, also where the appellate division held that it's necessary to plead waiver. So it's trite. It's necessary to plead waiver. Without the Labour Court having made a final finding on preemption, the respondents in this matter, if they wish to rely on the waiver of the right to appeal, would necessarily have needed to plead the waiver of the right to appeal. Notwithstanding that, I'm going to move on to the next point, which we'll assume for the purposes of the argument that the preemption point is raised and before the court. Just as a way of background, the preemption issue comes into play when one takes into account, well, as it was argued, at least in the Labour Court, that the applicant demanded payment of the compensation that the Labour Court decided to award in his favour instead of the order of reinstatement. The issue then goes down to whether or not the applicant is preempted by this. Now, the applicant's case in his notice of application to appeal, he attempts to address this, although I will submit that this does not work to the respondent's benefit. The respondent cannot rely on the applicant's raising of preemption to say that the applicant has, in effect, waived his own right. But insofar as this court does wish to hear the submissions on the preemption aspect, I submit that notwithstanding any factual basis for preemption, this court has a discretion, and I submit it ought to exercise that discretion to overlook any preemption. The basis for this principle, and the basis for this principle and this court's discretion, comes from a very old matter, Paddock Motors versus Igesund, 1976, 3 SA 16. It's an appellate division matter where the question before the court in that matter was whether an express but legally incorrect abandonment of a legal point could interfere with the court's overarching duty, the appellate tribunal's overarching duty, to ascertain whether the court below it came to the correct conclusion. The essential issue in that case was whether or not whether it was a simple contractual dispute, and the question, the issue that was abandoned or waived was whether or not a condition precedent to the contract had been met. The court found that if an express abandonment could preclude the appellate tribunal from giving the correct decision, one that is considered on the basis of an expressly abandoned legal point, that would lead to an intolerable situation. The appellate division, a nice quote from the appellate division, is that this would lead to a fruitless exercise, divorced from reality, and may lead to the wrong decision. Accordingly, in that matter, the court resolved that if the legal contention abandoned is good and the opposing point contended is bad, then by refusing to investigate the good point, it would be upholding the wrong order, and this would be intolerable. Therefore, the court found that it was permissible to allow the applicant to revive its abandoned contention. This is relevant. The nature of this point is relevant in this matter because at paragraph 35 of the respondents' heads, they raised the gravity of the issue at stake here, saying that the gravity of the issue being the applicant or the appellant's right to security of employment is not equivalent to some of the other cases I'm going to talk about later. The fact is, where this principle stems from is a simple commercial contractual dispute, one where it doesn't even concern constitutional rights. It's not, the question has never been about whether or not the court determines that it has sufficient gravity to overlook preemption and to hear the appeal anyway. It's whether or not the court would be upholding something that is legally incorrect. The next matter that I want to discuss is the matter of Government of Republic of South Africa versus Von Abo, 2011. It's an SCA decision that is fairly well known. In this matter, it applied that principle that stems from the Paddock Motors decision in the context of preemption, the waiver of the right to appeal. The relevant question in that matter was whether or not the separation of powers between the executive and the judiciary and the encroachment of judiciary into the executive. However, in that matter, the appellant's conduct had given rise to the strong inference that it had objectively waived its right to appeal the impugned order. And I want to note that it also did on incorrect legal advice, similarly to the previous matter of Paddock Motors, where the waiver or the abandonment also happened in the context of an erroneous legal concession. The Supreme Court of Appeal in the Von Abo matter found that the order of the court de quo was legally untenable due to its conflict with established, two reasons, due to its conflict with established legal principles and due to the factual basis not supporting the legal conclusion reached in the impugned order. These two reasons are important because they come into play in this matter at hand as well. So, citing Paddock, the Supreme Court of Appeal held that it would be similarly intolerable if it was precluded from investigating the legal soundness of the first order as a result of the incorrect legal advice or the incorrect legal concessions, notwithstanding the order under appeal being clearly legally unsound. Accordingly, it ruled that it could hear the appeal notwithstanding the preemption. The next case that also deals with a similar aspect is the Minister of Defence versus South African National Defence Force Union. In that matter, it was similarly, once again, a matter of incorrect legal advice resulting in the conduct which gives rise to the inference, strong inference of an objective waiver of an appeal. The court held that notwithstanding this, it must be open to a court to overlook acquiescence where the broader interests of justice would otherwise not be served. Then we finally come to the most recent matter dealing with this aspect, the SARS v CCMA matter. The principal development that came out of this constitutional court matter is that the enforcement of the Constitutional Court held and indicated that the enforcement of preemption is subject to the Constitutional Court's duty to entrench constitutional values. In this matter, the Constitutional Court was dealing with the constitutional right to equality, non-racialism, and human dignity. Similarly to the previous matters, the appellant had conducted himself in such a way that would give rise to the unequivocal inference that he had waived the right to appeal, and once again, it was based on incorrect legal advice. Notwithstanding this, the Constitutional Court, in determining the broader interests of justice, held that the enforcement of preemption is obviously subject to their duty to entrench overriding constitutional values, coupled with the fact that preemption was based on the incorrect legal advice. So here the Constitutional Court expressly referenced the fact that incorrect legal advice was the basis for the waiver. This rendered the hearing of the appeal to be in the broader interests of justice, and in such circumstances, the court ruled that it could depart from the abundantly clear decision not to appeal. So now we come to the current matter. In the current matter, we are dealing with the constitutional right to fair labor practices. The Equity Aviation Services versus CCMA matter, the 2008 Constitutional Court matter, held that the right to job security is a core value of this constitutional right. If the conduct of the appellant in this matter does lead to the objective, and if this court finds that the conduct of the appellant does lead to the objective inference that he has waived his right to appeal, it is submitted that he does so on incorrect legal advice. This is evident when one looks at the facts alleged by the applicant, that shows that his attorneys, that he instructed his attorneys to demand the funds necessary to fund the very appeal that he's now being claimed that he's preempted from prosecuting. In effect, his attorneys failed to advise him that by demanding the monies, he would have been preempted from prosecuting that same appeal. Notwithstanding these established principles relating to preemption, his attorney simply carried out the instruction and didn't advise him otherwise. Clearly, the applicant incorrectly and erroneously conducted himself in a way that would give rise to the inference that he had waived his right of appeal, and this was a result of poor and incorrect legal advice. It's submitted that for the reasons that outline in the main argument, the impugned order in this matter is similarly legally untenable for the following reasons. Firstly, the Labour Court breach established legal principles. These are set out in these legal principles are set out in the Jabari and Crocombe decisions, which are discussed in more detail in page 30 of the main submissions. The next reason is that the factual basis, in particularly the evidence regarding the employment relationship, does not support the legal conclusion reached by the Labour Court. This was dealt with in more detail in the main argument. But this is similar to the aforementioned SCA decision where the factual basis didn't support the legal conclusion. It's exactly the same here. And finally, the Labour Court's order breaches the fundamental right to fair labour practices, particularly job security. In the circumstances, it's submitted that it will be in the broader interest of justice for this court to not enforce any waiver of the applicant's right to appeal, as the alternative would be for this court to uphold a decision which is patently legal, which is legally untenable, and which violates the aforementioned constitutional right to fair labour practices, and where that preemption is based upon erroneous and incorrect legal assistance of the applicant's erstwhile legal representative.
Mr. Grabler?
Yes, Justice Pillay.
The countervailing consideration when you are dealing with preemption is the need for legal certainty. And here we have that the need for legal certainty in circumstances where there's an active step of taking the compensation, and secondly, delaying in challenging the decision. So how does one balance those rights of employer and employee?
Thank you, Justice. The applicant's conduct in demanding the monies, it can't be divorced from the context. The entire reason for demanding the monies was in order to fund this very appeal. The reason the appeal could only be prosecuted after receiving the funds was because the funds were necessary to institute the appeal in the first place. It's the legal certainty that may have been upset by the launch of the appeal. It cannot be said to have been so prejudicial to the employer, because it's not a matter of the applicant waiting years before instituting the appeal. It was very soon after receiving the money that the applicant then instituted the appeal.
If you say the money was demanded in order to prosecute the appeal, the demand for payment was made by the attorneys, was it not?
Yes, well, first the applicant attempted to demand the monies himself, and then he attempted to demand, and then the attorney sent a letter on his behalf.
Did the letter indicate at all that we want payment in order to prosecute an appeal, or did it just say pay us because the court said I must be paid?
No, Justice. The demand for monies did not indicate that there was an intention to appeal, but I just want to check the record. The demand itself, though, if I recall correctly, it did stipulate that the demand was for back pay, for the purposes of back pay, which clearly evinces an incorrect understanding of the difference between back pay and compensation by the attorneys.
But whatever terminology may have been used, the demand could only have been made because there was a judgment saying the applicant should be paid. So it was payment pursuant to the court order, not so?
Yes. As the applicant alleges in the application for leave to appeal, he was under the impression that he could have just simply demanded the monies to fund his litigation. He had no idea that he would need, at that stage, and it's clear that his attorneys did not know either, that they would have needed to indicate to the respondent that they still had wished to appeal. They believed that they could.
Yes.
Sorry,
I must understand your submission in responding to my sister Justice Pillay to mean that when the demand was made, the applicant already knew that he wanted to appeal.
Yes, that.
So and he made the demanding, acting all on his own initially. So that must mean that when the demand was pursued on his behalf by his attorneys, the attorneys were already aware that he wanted to appeal.
Yes, that's the applicant's allegations, is that it was in order to fund an opinion on the prospects of an appeal, on whether he could appeal the matter.
And then the attorneys, and one assumes that the attorneys would have been aware of the concept of preemption of an appeal. The attorney is well aware that he wants to appeal, keeping mum about it. Is that not suspicious? Is this not an indication that it's an afterthought that throughout or right from the onset he knew that he wanted to appeal?
It's true that he was represented by attorneys at that stage when he instituted the demand, but I want to point out that in all the aforementioned authorities that discussed this matter, in those cases, the appellants were similarly.
I'm asking at a factual, this is at a factual level, so I don't think those authorities on which I think you quoted them for the principles that they enunciate, I don't think they can be of assistance to you on the factual issues I'm raising with you.
Sorry, Justice, could I ask you to just repeat the question?
I said, is it not possibly an afterthought that is now saying right from the onset when he made the demand, he wanted to appeal, he wanted the funds in order to appeal?
Well, if one looks at his conduct in consistently challenging the decision to award him compensation instead of reinstatement, it gives rise to the strong inference that it was always the appellant's intention to appeal the compensation order. Indeed, he got that reinstatement order and had fought tooth and nail up until the LAC. Indeed, he went further and drafted his own constitutional court leave to appeal application papers. It cannot be said that this is an undetermined approach and a lackadaisical way of going about things. He tried his best.
Thank you, Mr. Grobler.
Thank you, Mr. Grobler.
Thank you, Mr. Justice. I'm going to give the seat over to my senior.
Mr. Kroon.
Yes, Acting Deputy Chief Justice.
That concludes your oral submission.
Just two very brief points. If Mr. Booi is able to persuade the court, then obviously any order would have to make allowance for the money which he has already received. And then I'm sure the court knows that perhaps we should have placed it on record at the beginning. We are acting pro bono. We have asked for costs in the event of success based on the Morcall decision, which we've referred to in our heads.
And then on that aspect, if I may just ask on the remedy, if we are with the applicant, the delays that have already been mentioned, shouldn't they be taken into account and when considering the remedy? That's to Mr. Kroon.
Yes, that I must concede would be fair, and we would leave that in the discretion of the court, but I can't in good conscience argue that public funds should be utilized for delays which were occasioned by Mr. Booi.
Thank you.
Thank you, Mr. Cron. Mr. Leroux.
Thank you, Acting Deputy Chief Justice. Let me deal briefly with what my learned friend, Mr. Grobler, has dealt with towards the end, because I want to say very respectfully that although it was dealt with briefly and towards the end, it is not to be trivialized, the issue of preemption, particularly in light of the facts that have become apparent as they are on the papers and as they have been confirmed in response to questions posed by Justice Madlanga, for example. When the applicant sought payment himself, he sought payment, as we see from his letter. He said, please indicate when can I expect payment as per the judgment. And you have been told that that was conveyed with the subjective intention on the part of the applicant to fight that self-same judgment. Not long thereafter, the matter is pursued by his attorneys. They say specifically that he has been awarded back payment in an amount of 700,000, which they clarify as being a little bit more in a subsequent letter. And so we know factually that at that time, the applicant, while harboring the subjective intention, he says, to fight the judgment, is pursuing its enforcement. And self-evidently, the municipality deals with it on that basis, because of course it cannot deal with the applicant on the basis of an unspoken subjective reservatio mentalis that he has. It has to take him at his word as put in writing, and so it performs in terms of the judgment. It performs and it pays out approximately $750,000 rand. It's not one of those matters as in say NDU where nothing turns on the about face that a litigant has effected. This litigant seeks and secures payment and keeps that payment to the present day. And until my learned friend was asked a question by the court, he has to this day not tendered the return of that which he sought and obtained. And I must suggest that there cannot be a clearer example of preemption than just that. And then the only real question becomes, is there something...
Mr. Leroux, I'm sorry.
Justice Jafta?
Do we know on the facts whether we know that he was taken to have been dismissed?
Yes.
Do we know on the facts whether he had other sources of income to sustain himself?
Justice Jafta, no, we don't.
So he could not have asked for payment lest it be held against him that he has preempted.
Indeed.
How so?
Well, Justice, it would go back to the fundamental principle that one cannot, to put it, and I mean it respectfully, that you cannot sit on two chairs in legal terms. Either your option is to be dissatisfied with a result that has been rendered, in which case you choose to fight it, or you choose to acquiesce in it, and then that has its consequences. And that
which authority says if you get paid under a judgment, that is enough to show that you have preempted?
Justice Jafta, there are two authorities. The one is referred to in heads of argument. It deals with the corresponding situation, albeit from the perspective of the employer. And that is the Venture Otto versus Stevenson judgment. And I suggest that the principle is on all fours, even though the role of the parties is switched around. On the facts of that case, the employer receives a favorable award. The employee receives a favorable award. The employer says, can we not pay you now, early in the month? Is it okay if we pay you in the pay run? The employee agrees. The employer subsequently does an about face and now wants to review the award. The employee pleads preemption. That is upheld by the Labour Court. That authority is referred to in my list of authorities, but I've come across a further one, if I may just have a moment. Going back to the collective level, I'm sorry, I will deal with that very shortly. My apologies. But in any event, Justice, of course, it all goes back to the leading decision that is always cited in the Dabner case. And indeed, the Constitutional Court in the SARS matter.
No, let's deal with the one that you said. It was the employer. Can we equate an employer to the situation of an employee? Because my understanding is that if an employee is dismissed, they have no other source of income. They are promised that there is a payment that comes from the judgment. Is it realistic to expect them to starve to death because they want to challenge the judgment on appeal? In the case of an employer, the situation is different. The employer doesn't need the award that you're talking about to survive. Here we have a situation of someone, and we know in this country that most people rely on the income of their salaries. If you take away that salary, the person can't survive. Now, I want to understand how that becomes a sufficient proof of an unequivocal, as I understand the standard is, it must be an unequivocal display of acquiescence to the judgment. It seems to me, yes, it may be a building block towards that. How can it be sufficient in the circumstances of this case? Perhaps in the circumstances of the employer, it may well be, but how can it be an unequivocal indication that he accepts the judgment?
Justice, I submit that, let me deal with two aspects arising from that question and start where you've ended off.
Yes.
The first is, what is it that makes it unequivocal? That raises the question, unequivocal in terms of what? The answer to that must be unequivocal in terms of wanting the judgment to be given effect to, and why that on the facts of the case must be answered in the affirmative is because both the applicant and his attorneys in express terms say that they want payment as per the judgment.
If they had said payment in order to fund an appeal, would you still say unequivocal?
No, but then of course the employer wouldn't have paid. because the, of course that's
no, but we're testing the proof of unequivocality.
Yes.
We're not testing the proof of what the employer could have done, isn't it?
Yes. No, indeed. But let me just deal with my it goes to a very serious point that was raised with my learned friend, namely, what is the point of having this construct? And the point of that construct, I would suggest, has to be at least two things. It has to serve justice as between the parties, and secondly, it must facilitate legal certainty. Now, what is and I put it in direct terms, what is the utterly unacceptable result that is achieved here? It is the fact that you persuade your employer in express terms that you want compliance with the judgment, and you want a consequence, and you have the benefit of that consequence, and they pay you while you keep silent. Now, how can that be right? It cannot be right, because that silence is tantamount. It's not tantamount to it is bringing the other party under a false impression as to your intentions, so that they will act. Because if you'd been upfront and truthful, they would not have paid, because they would obviously have said to you, well, clearly you are rejecting the judgment. Please tell us unequivocally, are you complying with the judgment or are you appealing? But you cannot have it both ways. That is I submit that is essential as to the proper conduct of relations, even as between litigants. But you cannot, in a sense, induce a payment by your silence based on the reservatio mentalis. Let me just make this final point, Justice Jafta. It has to be so if the commercial world, and I don't want to reduce everything to pure commerce, but it has to be so for the sake of commercial certainty that we treat people's conduct on the basis of the external manifestations thereof. I cannot go around signing contracts and resiling from them, subsequently saying, well, you know what, when I entered into that agreement, I actually had a reservatio mentalis. I didn't mean to bind myself. And therefore, in this context also, it is the external manifestation of conduct on the authority that I've put in our heads of argument. It is the external manifestation that is determinative. May I deal with the other aspect arising from your earlier question? And of course, you put the question in stern terms when you say that do we expect indigent employees to starve to death because they cannot, at least on an interim basis, have the fruits of the judgment or the award that they have received in their favor. I would submit with respect that if there is such an exception to the ordinary principles of preemption, it is not one that, to the best of my humble knowledge, that I have come across, where a party is released from his or her bargain or conduct purely on that basis. But on the facts of the case, that case, that is not what Mr. Booi put up in any event. At the high water mark of what he says in terms of financial pressure, at the high water mark, he says that lawyers are expensive and I needed to find money to pay the lawyers. He does not put up an in extremis argument in terms of being at the risk of starvation. Secondly, he does not, in his condemnation affidavit before the Labour Court, as my learned friend Mr. Khobro tried to persuade you, he does not say that he made a mistake and he was acting on wrong legal advice when he sought payment. It's not the case that he advances anywhere. If one has a reading of that affidavit that he put before the Labour Court when it had to consider leave to appeal. If
we were to order him to repay the money, what prejudice would your client suffer?
Justices, there would be, I cannot in good conscience say that there would then be direct financial prejudice, in the sense that with the necessary calculations and allowances concerning interest and whatever the case may be, with the necessary effort, I think the financial scales are capable of being balanced. But of course, there is the second aspect. Well, there are two other aspects. There's a second aspect that the municipality would have ordered its affairs on the basis that an election had been made. And thirdly, at a general level, I would suggest that there is risk in diluting the importance of preemption out of potentially sympathy for the applicant in this case, of diluting those principles to an extent that will, in the broader scheme of things, be damaging to the needs for legal certainty and the need for parties to know where they stand with each other in the conduct of litigation.
But you know that the guiding principle is that of the interest of justice.
Yes.
So if we find that it is in the interest of justice to take the matter and decide, provided that the municipality doesn't financially become disadvantaged. I'm not quite sure how that is constitutionally objectionable. You can tell me if it is.
Justice Jafta, I'm not going to suggest that at the level of broad principle, no such limitation on preemption exists, because clearly it does exist, as the SARS versus Creer case demonstrates. What I do submit, however, is where that exception has been recognized, it has been recognized in quite narrowly. And the SARS case illustrates one example of that. And I quote, of course, from that judgment, the Judge President's description of the issues at stake in that particular case. Secondly, if one were to turn to the SAN-DU case as perhaps the other highest level case at which some exception has been recognized, that was a matter in which the considerations that led the court to not consider itself bound by preemption was firstly the complete absence of prejudice, and secondly that it would have broad-ranging effect on, I think the description was, the National Defence Force or a significant portion thereof. Now those are quite extreme, and I would suggest narrow exceptions to a principle that should not be readily diluted, given what is at stake in the broader scheme of things. Against that must be balanced what is at stake in this case. Now, justices, I suppose this also goes to the extent to which the Constitutional Court should deal with the matter. The irony is, of course, in a sense, it is dealing with it as we speak. But what is at stake is one litigant who is dissatisfied with the manner in which the scales have fallen in a very particular case, and he feels that it ought to have fallen this way and not that way. I submit with the greatest respect, and without suggesting that it's unimportant to Mr. Booi, without suggesting that it's unimportant to the municipality, it is very important. But we are not dealing with matters in which I submit a further exception should be crafted in order to accommodate Mr. Booi.
Do you accept that the Labour Court was very critical of the municipality in how it went about trying to get rid of Mr. Booi by putting up unsustainable charges when its complaint was that of poor performance. You accept that?
Justice, no, only with significant qualifications. So let me confront that. Let me confront that directly. Of course, I see that the Labour Court considered towards the end of its judgment, considered the charges to be unsustainable. Of course, I can see from the self-same paragraph in the judgment that the Labour Court took the view that misgivings about Mr. Booi's performance ought to have been approached differently. The Labour Court did not reach the conclusion that there was a plan afoot on the part of the municipality to improperly rid itself of Mr. Booi. Neither the Labour Court nor the arbitrator reached a conclusion in those terms. And for that reason, I would, with respect, take issue with the description of putting it in terms of getting rid of. Not every employer who puts up a basis for dismissal that is not upheld must be considered to have crafted an improper scheme. There's not an evidentiary basis for that.
Let's drill with a bit deeper on the facts. The facts are clear that none of the charges were found to be sustainable. He was exonerated on all of them. Is that not correct?
Well, Justice, let me perhaps just deal with that. What the Labour Court fundamentally found was that given the limitations of the test on review, that there was not a sufficient basis for interference. It deals with that at paragraph 14 and 15 onwards.
But the arbitrator found that none of them stick.
Yes.
Yeah. So we proceed from that.
Yes. So let me, if I do so, firstly, I say that the arbitrator's finding that did not go higher than to say guilt was not established. The arbitrator's findings did not extend to an improper scheme to get rid of Mr. Booi. Now we come to what the Labour Court said. What the Labour Court said, well, given the test on review, the conclusion reached by the arbitrator is not so wholly unconnected to the evidence that it can be said that it's a decision that no reasonable decision maker to which it could come. So it's not, I submit.
Now, Mr. Leroux, for the sake of time, because I want to ask one or two more questions. We know that the employer was aware of the outcome of the findings by the arbitrator. And the employer went to the Labour Court wanting to challenge that, and it did not succeed. But still the employer wanted him out on the basis of section 193 sub 2. Is that not correct?
Yes, save for the description of wanted him out, but the employer absolutely resisted reinstatement. Let me put it that way.
Yeah. No, but it means he's out.
It
He's
wanted
not
him
in,
to,
is he in?
No, it wanted him to remain out.
Exactly.
On the net result, we agree, Justice Jafta.
Yes, yes. So, and we know that the evidence relied upon for resisting reinstatement on the intolerability issue is the evidence of a witness who also testified in relation to the merits of the misconduct charges. Is that correct?
Yes, Ms. Mlungisi did testify in relation to the merits. The record shows that.
And her evidence was not found to be establishing the misconduct.
Yes, that is so. Let me say in the same breath, the only extent to which any aspect of credibility specifically featured in that analysis concerned a meeting where the question arose of whether or not a raised voice had been used to the extent of whether or not that should be called insubordinate. For the rest, the findings in favor of Mr. Booi did not rest on adverse credibility findings in relation to Ms. Mlungisi, but rather the general conclusion that the evidence did not go far enough to demonstrate guilt, particularly insofar as, for example, a dishonest intention on Mr. Boi's part could not be established.
Now, how can it be said then that it was unreasonable of the arbitrator, having found that that evidence could not establish the misconduct? How can it be said it was unreasonable for the arbitrator not to rely on the evidence of that witness for purposes of intolerability?
Justice Jafta, for two reasons. Perhaps for three reasons. So let me deal with them.
Yes.
The first is, to the extent that her credibility arose, it arose solely in relation to the one charge to which I've referred, the raising of voices charge, and as an elementary principle, one does not assume false in one, false in respect of everything. So that was a confined conclusion in respect of that charge. But more importantly, let's deal with what she then says in relation to the relationship. What is and in essence, your question goes to the question of, well, is she making all of that up? Is she artificially making things to sound worse than they truly are?
No.
Under that, I'm sorry.
No, it's not. I think you're missing the focus of my question. The focus of my question is the standard for interference with the award is that of reasonableness.
Yes.
Now, having looked at the case holistically, how can it be said then that the decision reached by the arbitrator in the face of the fact that on the merits, the evidence was found not to be sufficient to establish the merits of the same witness? How can it be said that her decision was so unreasonable that a reasonable arbitrator could not have made it? That's the focus of my question.
I understand, Justice Jafta, and I'm trying to make my way there. I apologize if I did it in too elaborate a way. Okay. So the reason why I dealt with Mlungisi's evidence as I've done is to firstly deal with this, with the state of the relationship from employer perspective. How will the debate go? Arising from your previous questions, a suggestion may be that there are doubts about Ms. Mlungisi's credibility, and therefore we should also doubt what she says about the state of the relationship. That's how that argument would go. And the way I was trying to deal with is firstly to say one must not project doubts about other aspects of her evidence onto her evidence about the relationship. Secondly, and I submit so decisively, Mr. Booi did not see differently in relation to Ms. Mlungisi's Ms. Mlungisi's views. I'm going to come to his views. I'm only dealing with Mr. Boi's attitude in relation to the views expressed by Ms. Mlungisi. And the record shows that he did not dispute that that is the way that she feels. In fact, that is part of what was deliberated earlier on as to what was the extent of what was acknowledged from Mr. Boooi's side. So Mr. Booi did not say Ms. Mlungisi is making it up when she says that she feels this way about our relationship. So her views were not on that point, were not contentious. May I come?
We were referred to a portion in the record by Mr. Kroon, where he said when Mr. Booi wanted to challenge the correctness of that evidence, a representative of the employer said, well, this is not relevant, objected to it, and the arbitrator upheld the objection. Would you, in the course of your submissions, deal with that?
Yes, indeed, Justice Jafta. If I may just round off this point, because it's quite, and I promise to deal with that. It's just important that I encapsulate this point,
yes,
in its totality, because it's quite central insofar as we say the issue is the reasonableness of that aspect of the arbitrator's decision. If you turn to page 282 of volume 3, that's the transcript. And when I say page 282, that's a passage also referred to by my learned friend, Mr. Kroon. I'm talking about the typed page 282 top center. It also has the handwritten number 279.
okay.
And in the first 8 lines there, Mr. Booi is asked for his views about Ms. Mlungisi's views. And the conclusion, so to speak, to which he comes is, and this is particularly at lines 7 to 10. I may paraphrase it as to say, I don't dispute that she feels that way, but don't misinterpret my words to say that I, as Mr. Booi, that I'm saying I can't work with that. It's for this reason, Justice Jafta, Justices, that I say that it wasn't controversial before the arbitrator that Ms. Mlungisi, rightly or wrongly, genuinely felt this way. I will come to Mr. Boooi's views from the flip side of the coin.
No, but is the test subjective or objective on this issue?
Justice Jafta, it is, of course, a feeling is in a sense subjective, but you will ask yourself as to whether or not that's a reasonable sentiment. You will ask yourself, where are there objective reasons underpinning that sentiment? Can I understand why that person voiced that feeling? And I submit that on this record, we do have evidentiary material that underpins the way that Ms. Mlungisi feels here, with there being no basis to throw out all of those simply on the basis that, not that this was Mr. Boooi's case, but not on the basis that she's simply making up her feeling. It is underpinned. I'm sorry.
I'll allow you to continue answering the question, Mr. Leroux, because it takes longer. I thought the portion that you have referred us to was relating to him saying, I can't dispute that he felt that way, but I don't agree with that. So, yes. So that concerns me, because I know the test to be objective. The arbitrator or the labor court must be in a position to say, on the facts established before me, the relationship between the two parties has so broken down that I can't order reinstatement.
Yes.
Is that correct?
Yes, indeed, Justice Jafta. I'm not suggesting that a mere subjective say-so on the part of Ms. Mlungisi is determinative. The question will be whether the objective evidentiary material, and the Labour Court noted this expressly. The question will be whether the objective evidentiary material supported that. Now, in terms of the way that Ms. Mlungisi felt, in terms of objective evidence as to the state of the relationship from employer perspective, Ms. Mlungisi referred to Mr. Booi's conduct on a number of occasions, as I've referenced in my heads. May I just come to the flip side, because I found it difficult to progress also to make the same point from Mr. Booi's perspective. What does the record demonstrate from employer perspective? And I emphasize from employer perspective because I will come to employee perspective. From employer perspective, in relation to Mr. Booi, it demonstrates somebody with whom Mr. Booi at a management level has to work, who has lost all confidence in him, lost all trust in him, and who says, I've never come across somebody like that in my 9 years as a director. I've never seen anything like this. That is the state of the relationship demonstrated by the evidence from employer perspective. What does Mr. Booi say?
And is it correct that one of the charges of misconduct was insubordination?
Indeed.
Okay.
Let me deal with it from employee perspective. Now I know full well that if you were to turn back one page from page 282 to which I've directed your attention, you will find slightly more positive things, such as they are being said by Mr. Booi. What does he say? He says we have a challenging relationship. He says there are sour relations between us. He accepts that she doesn't want to work with him anymore. He says that he can't dispute that that is the way that she feels. What is Mr. Booi's state of mind? Subjective, objective, call it what you may. Just what are the facts before the arbitrator? The facts before the arbitrator is that from Mr. Booi's perspective, he's being victimized. His employer is treating him so badly that he routinely has to go around making surreptitious voice recordings of his dealings with his employer. So now I say to you, to this court, how could the arbitrator, faced with that level of distrust expressed from employee perspective, faced with that level of distrust from employer perspective, how could the court reasonably conclude that there was a viable employment relationship characterized by what this court and all the inferior tribunals have always said, characterized by a relationship of trust and confidence? How do you reasonably come from this factual scenario from both sides? How do you get from the one to the other? And therein lies the reason why we say that the Labour Court spotted it entirely correctly. Let me perhaps just deal with this where it then takes us. I appreciate the initial discomfort with saying, hang on, somebody has been exonerated. How is it that he is not reinstated? Well, we know from the SARS judgment and all the others to which we refer in the authorities that the one doesn't inherently flow from the other. Reinstatement will usually follow, but it will not always follow. There may be reasons that preclude reinstatement on the facts of a case.
But in the SARS judgment, there was no exoneration.
Let me point you to a different, perhaps the most recent authority. Let's perhaps just for the moment dwell on the SARS judgment. What there was at a point from employer perspective, unlike this case, what there was at a point in the SARS judgment was the employer's willingness to not even dismiss. The employer's willingness not to even dismiss That's at an early part of the history in the SARS case, and then, of course, it took its history from there. Let me come to another example of an employee cleared of the charge against him, that which formed the basis of the dismissal, and that is the Boyson judgment. So the employee, Mr. Boyson, is found innocent of that which formed the basis for his dismissal, statutory rape. And the Labour Court, through the same judgment, and the Labour Appeal Court then upheld that on appeal. The Labour Appeal Court said, well, it's not the end of the matter that you were cleared of that which formed the basis for the dismissal, because we must still look at where this leaves us. And that is precisely the same issue that confronted the Labour. Now, one shouldn't, one must think through a principle to its logical implications. If you are going to say, hang on, exonerated in relation to the actual charge as it was framed, then you would have to say, well, Mr. Boyson was cleared of statutory rape, end of story. We need not concern ourselves about the fact that he's somebody in the employ of the South African police who, on his own version, had intercourse with a minor, because that wasn't the charge. That's where one ends up if one takes that road. May I make another point concerning the structure and the purpose of Section 193?
Was the Boyson matter, was he charged with a criminal offense, or was he charged with misconduct? And what was that misconduct? I'm not sure I follow you.
Yes. If I may just quickly turn back to where I have it in my bundle of authorities. I'm sorry to delay you, but my recollection when I read the judgment, that it was misconduct in the form of having committed the offense of statutory rape, but it goes to the same principle, of course. It is just a misconduct.
Now, if he is cleared of the criminal offense, what misconduct remains?
Well, that precisely was the argument from the perspective of Mr. Boyson's. I'm sorry, was your question about Mr. Booi or Mr. Boyson? I'm sorry.
Mr. Boyson, I'm trying to understand if the misconduct was that you committed a crime and it is proved that he did not commit a crime, what would be the misconduct?
Well, indeed, that's why he was found guilty. He was cleared of the misconduct for which he was dismissed. Now, on the logic that you are asked to follow in this case, that should have been the end of the matter, and Mr. Boyson's reinstatement ought to have followed as a matter of course. Let me amplify that to one greater level. This was a matter in which, as the Labour Appeal Court judgment shows, was a case in which the police had led no evidence in relation to any of the factors in Section 193. It put up no case in that regard, which is much less than the employer in this case has done. The employer in Boyson's case put up no case in that regard, but the Labour Court said, well, despite that, the arbitrator should have looked at this. The fact that he was cleared of that which formed the basis for his dismissal is not the end of the story. You must then examine the factual matrix and ask yourself, well, is it a matter in which reinstatement ought reasonably to have followed? I submit with respect that this judgment is absolutely in point, and it was handed down 2 months ago. It's absolutely in point in relation to a number of principles that are pressed in this case.
If we find that it was wrong, because I don't understand how, where no factual foundation has been laid for saying that the employment relationship has become so intolerable that reinstatement should not be ordered. For a court to say, well, you have to look for something, even if no evidence was laid in that regard. And my understanding is that the onus is on the employer, where the employer wants to have the employee not reinstated because of the relationship that has broken down. The onus is on the employer to lead evidence in that regard. That's my recollection of the Labor Appeal Court jurisprudence. Now, for it to say in this specific case, well, it doesn't matter that no evidence was led, we're going to find that even though he was cleared on the misconduct, that reinstatement ought not to have been ordered. I have difficulty, one, because one moves from the perspective that what we are evaluating is the reasonableness of the award by the arbitrator. In those circumstances, how do we get to the point that the award by the arbitrator was so unreasonable that it could not have been made where there's no evidence on the relevant issue by the party that bore the honors? What worries me, Mr. Leroux, is this, which yes. I put to Mr. Kroon. It yes. seems to me on that approach of applying section 1932, one would say possibly it can happen that the employer would dismiss the employee for no reason whatsoever. And when that dismissal is challenged before the CCMA, the employer leads evidence on the intolerability, knowing full well that even if the arbitrator says the dismissal was substantively unfair, the arbitrator would not order reinstatement, because once there's proof of intolerability, then the employee must be given compensation. If the employer is willing to pay him off, for example, they can misuse the law. That's my concern.
Just, I appreciate the concern, and I've tried to distinguish that into three aspects. So let me deal with them. Firstly, in relation to onus, the best authority that I'm aware of is that to which we refer in our heads of argument. And rightly or wrongly, the Labour Appeal Court, I think it was in the Mediterranean textile mills case, has said that this exercise of the statutory power in section 1932 is not something that specifically attracts an onus either way. That is the way that the LAC has dealt with the question of onus. Secondly, coming to the potential for abuse. Well, the authority recently added by my learned friends, now the name of the municipal manager escapes me, but the case to which my learned friend referred you, in which the employer did pretty much, I think, what you have just described. It simply terminated. That dismissal was found in the High Court to have been unlawful, and it put up flimsy, bold allegations by senior politicians saying the trust relationship was broken down. And the result was predictable. It lost. So what that demonstrates, of course, is the trite principle that mere say-so will never get the employer home. And I'm not asking you to find or to establish a principle saying an employer can simply dismiss, come and make bold allegations about the trust relationship and avoid reinstatement. It has to be factually specific. And that brings me to the third element, applied to the facts of this case. This is not a case, I submit, this is not a case in which there was no evidence. Let me distinguish two aspects. There was not sufficient evidence to demonstrate guilt on the charges. There was, I submit, sufficient evidence to demonstrate a dysfunctional employment relationship. It was an employment relationship in which Ms. Mlungisi, as the direct superior, said, I've never dealt with such a person and I can't ever work with him again. And it is a relationship in which concurrently Mr. Booi is saying, I have to go around and record my superiors because I think they are conspiring against me and trying to get rid of me, and they are perpetually victimizing me. And that, I submit, answers the question. On what basis can it be reasonable to say on the part of the arbitrator, I've listened to what these people say, but I think this is going to work out. It's a jump beyond the realms of reasonableness to listen to those two people and thinks it's going to be okay, and they're going to have a cup of tea and work it out.
Thank you.
Mr. Leroux?
Mr. Leroux, can I just follow up on that point?
Yes.
Am I wrong if I say that this seems to have been relationship issue between two individuals or a clash between two personalities as a result of an alleged poor work performance? The reason I'm asking that is that when you look at Ms. Mlungisi's evidence in page 149, she says, and I know that this is not the only reference, she says that she even asked or inquired whether it was possible for Mr. Booi to be transferred to another department.
Justice, may I deal with that? Firstly, I would say that one should not read into that specific passage, and you have said that there are other passages. What I would suggest, the most compelling conclusion to be drawn from that passage is that in organizations people tend to shuffle the problem around. Everybody might say, well, all right, if I transfer him somewhere else, at least it's not my problem. It's not my problem anymore. So it may go no higher than that. But let me just illustrate why we say.
Can I, sorry to interrupt, but you do know, I'm sure, that there are interventions that usually take place in the workplace, like relationship building initiatives and so on, and mediations. And the fact that there is a clash between two personalities. As far as I understand the labor laws of this country, maybe I'm wrong, that factor on its own cannot lead to the inescapable conclusion that the relationship has broken down, or there is an intolerable relationship between the employer and the employee, because it is a clash between the two personalities.
Yes. Justice, Justice Chiki, I will not make the submission that whenever two witnesses come to an arbitration and they say, well, we've had our clashes and sometimes we don't see eye to eye. We don't see eye to eye. I'm not going to suggest that sort of situation lends itself to the denial of reinstatement, because there are differences that are sometimes resolved. Allow me to demonstrate, though, that this was not a personality matter confined to two individuals. If one has regard to the factors listed by the Labour Court in its judgment, and we refer to those with references in our heads of argument, those cannot be reduced to personality issues between two people. If we simply take it for now from the perspective of Mr. Booi, what Mr. Booi alleges, and this goes beyond Ms. Mlungisi, what Mr. Booi alleges as his justification for going around recording not only Ms. Mlungisi but other superiors is that he is the victim of a wide-ranging scheme to get rid of him. That goes beyond the realm of a mere personality clash as between two people. The next aspect to which, if I may refer you, is that it also extended to the municipal manager at the time, and towards the close of cross-examination of Mr. Booi, he was asked about that relationship, and it's perfectly clear that that is in its own right a troubled relationship, and he has a very he has a very straightforward solution concerning the municipal manager. He says about the municipal manager, no, people do make mistakes. So maybe it's a mistake that he's made. And essentially he's saying, well, the municipal manager must just realize the error of his ways in relation to Mr. Booi. This is not to be reduced to a two-person personality clash. Not even on Mr. Boy's word.
Well, concerning the relationship with the municipality, I don't know whether it's the arbitrator or the Labour Court that actually said that, in fact, the perception, or I think it's the arbitrator, after listening to the clip, the finding was that he was not insubordinate, but he may have been firm in the way in which he responded. But for me, that finding doesn't suggest that there was a clash in a relationship with the municipal manager. But apart from that, I looked at page 151 as well, where you will recall that there was that debate between Mr. Booi and Ms. Mlungisi about what was said during the disciplinary hearing. And Mr. Booi, in page 151, in trying to clarify that he actually did not agree with Ms. Mlungisi, that there was a problem with the relationship. He says, in the hearing, yes, that is now at the top 1, 2, 3, line 3. He says, I didn't say I don't want to work with him. He should have said here because he's referring to the director. And I was asked many questions by Mr. Mjebeza, and I even stated that it was not my house here. I cannot choose who I work with or under. I'm supposed to work with whoever who is in charge. He is now referring to the director. It just bothered me, Mr. Leroux, because this was a performance management issue that unfortunately the municipality decided to treat as a misconduct issue. We know what the arbitrator in the Labour Court said. And I keep on thinking whether, in fact, the reason we're having this debate is the fact that the municipality adopted the wrong process to address a problem, a performance management, a poor work performance issue.
Justice, certainly the arbitrator, and in the final paragraphs of the Labour Court's reasoning in relation in the Labour Court's judgment, it said that it felt that it ought to have been addressed by way of a performance management process. It says that in the context of remarking about how the employer dealt with the subject matter of the charges, and that criticism is in the Labour Court's judgment to be read. That does not mean That does not mean that we must conclude from this record that the sum total of difficulties within the relationship are to be found within the ambit of the charges. Instead, I submit that the proper consideration or the proper conclusion to be drawn is that the charges incorrectly crystallize certain specific concerns, but those concerns arose within the context of a generally dysfunctional employment relationship within which trust had completely broken down. Within that broader relationship, the employer then thought, well, this looks like misconduct. It was incorrect. It should have done differently in relation to the specific factual subject matter of the charges. That does not mean that the context is not there. It does not mean that the dysfunctionality in the backdrop is not there. We must not reduce the one. We must not reduce the one to the other, because I submit, and this is my central submission as to why the Labour Court was right. You cannot say that given what Ms. Mlungisi says, rightly or wrongly, given what she says about the state of the relationship and the lack of trust, with Mr. Booi saying in essence the flip side of that, you can't say that you look at that and you say that this allows the restoration of a viable employment relationship. And therein resides the unreasonableness in relation to the remedy. It really flows from a common cause state of affairs, much as Mr. Booi said, well, I'm prepared to work it out. But if you look at it neutrally, it was common cause that the relationship was in this state, because the reality test is this. Mr. Booi says he is so victimized that he has to go around making recordings of his superiors. How do you reconcile that with the conclusion that there exists trust, even on one side of the coin?
In the record and during Ms. Mlungisi's testimony, maybe you can help me find where she says that the trust relationship had broken down. The closer to that I could find was where I referred you earlier in page 149, where she just says it was the issue of trust. But she doesn't unequivocally say that the trust relationship had broken down, or it was intolerable, and I know that there is somewhere where she said that she personally had never worked with somebody because yes, she felt embarrassed and all of that.
Let me point you to one aspect where trust is specifically mentioned, and there may be others. I would have to just turn the pages quickly, but specific mention of trust is made in the passage that starts at the bottom of page 186 of volume 3. That's the transcript. I mean handwritten page 186. So she says at the bottom, in the light of all of this, Mr. Booi says he's not to blame for anything. As far as he's
handwritten 186. Yes.
Handwritten 186, and it flows to the top of page 190, where you only see 2 lines. She says, I can't work with him. The trust is not there. There she specifically mentions trust, but the other instances where it is implicit, if I may just turn to various other flags that I've, and see what else comes closest to that. The complaint on page 49 of the transcript is not focused on trust per se, but goes to respect for authority. Then at the top of page 51, Ms. Mlungisi is asked about what Mr. Booi previously said. She said, Mr. Booi said he can never work with me again. He doesn't trust me. The working relationship between him and me has been broken. He can never work with me. And
we know that Mr. Booi disputed that.
Yes, and yes, well, he disputed having said so on that particular occasion to which she refers. Then on page 95 towards the bottom, she talks not so much about trust, but rather about humiliation and embarrassment.
No, that's okay, Mr. Leroux.
Yes.
I think I've put my concerns to you.
Yes.
And the last concern really that I have is whether if this court agrees with you, it would not be endorsing a principle or a legal principle that says that if there's tension between a superior or a direct, or yes, let me say direct superior for lack of a better word at the moment. If there's tension between those two individuals in a workplace arising from poor work performance,
yeah,
and the employer then decides to conduct a hearing on the basis of misconduct, then it is acceptable to us to then rely on those tensions between those two people to find that the relationship between the employer and the employee is intolerable.
Justice, I don't think I'm asking for the approval of any principle in those terms. The only principle that I'm arguing for is to say that when it ought to be apparent on the evidence on record before an arbitrator that there is not a viable employment relationship characterized by trust and confidence, that there is not a viable relationship to be restored, then the arbitrator ought not to award reinstatement. The rest would be factually specific.
Should we ignore the fact that, in fact, the catalyst to the dispute were issues of poor work performance? The reason why this bothers me is that you know that the Labor Relations Act has decided to set out a different process on how to deal with issues of poor work performance. And those processes are different from how an employer should deal with issues of misconduct.
Just, Chiki, I suggest that it is not accurate with respect on the record to say that the problems that arose here all arose under the umbrella of poor work performance. Clearly, we are able to see that there were differences about work performance. But going back to the earlier point that I made, there are core events that crystallized into the charges when perhaps they ought to have been dealt with under the heading of poor work performance. But what precluded reinstatement, we say, are broader relationship aspects in the background that are present in this case and that may be absent in the next case. But matters such as those complained of by Ms. Mlungisi, such as arrogance and humiliation, those are not poor performance, not meeting your target kinds of issues. Conversely, aspects such as victimization, suspicions of your employer causing the making of the recordings, those are equally not to be considered under the heading purely of work performance issues. So the conceptual point I'm arguing for is to say that the focus of the dispute that resulted in dispute and in dismissal and that made its way, that focus was poor work performance / misconduct. In the backdrop, as it emerged from the evidence before the arbitrator, was a relationship that had become dysfunctional for reasons that go beyond the performance or conduct issues that directly resulted in the dismissal. Yes.
No, I don't intend to belabor the point, and I'm sorry, my sister, Justice Pillay. Well, what stood out for me was the fact that it seemed to me that what embarrassed Ms. and probably humiliated Ms. Mlungisi was when there was that meeting of the municipalities, and it turned out that Amathole municipality had not delivered, and that was put at the door of Mr. Booi and all of that. And I thought that all of those issues arose from the issue of poor work performance. Yes, I saw from the record that the municipal manager was not happy with his response, that the way he responded to an allegation and said, well, it is how the municipal manager perceived it. Other than that, I couldn't see anything else, but I mean, we don't have to belabor the point. You've answered me.
Justice, if I may very briefly say, I did not understand her evidence about humiliation and embarrassment as we find it at the bottom of page 95, running over to the top of page 96. It is said in general terms, it is not said for purposes of a specific meeting, and she specifically uses the plural when it comes to meetings, and she uses plural when she says to encounters, and she talks about humiliation while talking to him. The embarrassment, the disrespect is given me. Those are not specific to a given occasion contemplated by any charge. They are a general mode of behavior complained of.
Right.
Justice Mayor, I'm sorry.
Mr. Du Plessis, may I, sorry, Mr. Leroux, just on that point, it seems to me that if we're not invited to look at the evidence to make any determination about the arbitrator's finding about the relationship, because there's evidence that goes in favor of both parties, and one would need a lot more to say that either Ms. Mlungisi or Mr. Booi were responsible for the breakdown in the relationship. But that's not the agenda for this appeal, as I understand it. If I may take you to what triggered the process beyond the arbitration award is the employer, the municipality, reviewing the award. And I'd like to take you to section 145 and the grounds of review there.
Yes.
The grounds of review are pretty much imported from the Arbitration Act, and they are very limited. Very limited. Correct?
Indeed, Justice, I accept that.
And then the case law expanded these grounds to include no reasonable arbitrator could come to that conclusion. Am I right?
Indeed.
But that reasoning can't be outside the context of the legislation. So, as you will probably agree, you can disagree if you wish, that arbitrations under the Arbitration Act are seldom ever reviewed unless it meets the requirements of gross irregularity, ultra vires, etc., which is what is reenacted here in the in section 145. But it seems to me that the reasonable arbitrator test has exploded into this matter of course, par for the course practice of taking every award with which a losing party is unhappy with, taking it on review. Now, applying this test under 145, tell me what is the basis for the employer approaching the labor court? I cannot see any basis. You may disagree with the arbitrator's finding of reinstatement, but that is a finding based on evidence. And unless that evidence is unreasonable, or the assessment of it is unreasonable, there is no basis even on the case law to bring to review this award. And that is what triggers this plethora or these layers of litigation. And that is what puts a party like Mr. Booi to the expense of this litigation.
Justice, may I say this? Of course, those statutory grounds have had their developments over time, culminating in Sudumo. Then there was the question of whether the Sudumo test is in retreat. Then we came to Herald, and then to Mofokeng, and then there's the, I would submit, from somebody who usually plies the trade at modest level. There is today experience in the court where you just hope that the judge will find some point that bothers him or her in the outcome. So, and so one tries to predict this difficult beast of what is a reasonable outcome. And there's always a judgment that pulls the scope a little wider, and then which pulls it a little in the other direction. Because reasonableness is different things to different people.
Well, that's my problem, you see. The society is being lost of what the real purpose and scheme of the LRA was and conceived to be. As you recall, there were 6 labor court judges when the court started, precisely because the primary platform for resolving disputes was arbitration, in fact, conciliation. And so there's a problem with an award or challenging an award like this, when there isn't any of the grounds set out in the Act, and on the evidence you cannot advance a case that the arbitrator was unreasonable.
Well, Justice Pillay, if I might briefly turn to what was pleaded, and from there try to confront that question.
I've heard your submissions about how the arbitrator, which was the third point of third ground in your application to the Labour Court, that the arbitrator erred in reinstating and finding that there was wasn't an irretrievable breakdown. That's the crux of your case, isn't it?
Well, it's indeed, it's the only one that succeeded and that is being defended. I wasn't there. I can't comment on how good the case was on the merits, but it's the one with which I am tasked at this point.
Well,
yes.
We're all stuck with the record, and so we weren't there either. So we got to go with what the record is.
Yes, but may I say this about the record without belaboring that either, because I've put the references elsewhere. One cannot, I submit, one cannot read through this record and reasonably think that reinstatement will work out satisfactorily. That's my proposition on the record, and I say that Justice Pillay and Justices, on the basis that I don't think, and I know the Labour Court didn't think that it was essential to even distribute blame this way or that way. You cannot think it's going to work.
Sorry, Mr. Leroux. Let me move on because I've heard your arguments on that.
Yes.
My second point relates to the preemption issue that you raised.
Mm-hmm.
And the point I raised was Mr. Kuhn about certainty. Now, the principles that we uphold or establish in this case would cut across employers big and small.
Yes.
So there may well be a small employer who might borrow the money to pay off a compensation claim, only to find, if we uphold that preemption defense or point should not be upheld, that employer, being a small employer, would be faced with another bout of litigation.
Well, yes, and therein lies the difficulty in too readily, and please, I don't mean this either disrespectfully or in any negative sense, but one must be very careful where you end up in the bigger scheme of things before you open a particular door. So if one then says, well, I'm going to craft a further exception, it is going to be the economic hardship exception or the big employer exception or the small employer exception, or however you want to couch the terms of that exception to preemption, one must be very careful where that takes you. And the fact of the matter is that in relation to preemption, as it may be in relation to prescription and many other legal constructs, you will never have perfect justice. You may have the road accident fund claimant who's a day late and all of those matters, but one must be very careful before one simply invokes interest of justice and override quite an important construct.
Well, I like your phraseology. We won't have perfect justice, because that is precisely taking me back to my first point. And I'd like to stop on this, that both parties must understand that there isn't perfect justice and stop it after the arbitration. In fact, try and settle it at conciliation. Thank you.
Justices, I'm ready to deal with any other questions unless you've heard me sufficiently.
Thank you, Mr. Leroux.
Thank you, Acting Deputy Chief Justice.
Mr. Kroon.
Thank you, Acting Deputy Justice. Just one comment on the, sorry, I'm going to put my video on. Just for the court, for the court's information, the Boyson decision, which, with due respect to the court, was a controversial one. It almost gives the impression of the court being overly paternalistic or moralistic, but I won't ask you to comment any further. I've been made aware that there is an application for leave to appeal to your court on that matter, so I would just bring that to your attention. Other than that, I don't have anything in reply.
Thank you, Mr. Kroon. Judgment is reserved and the court is adjourned.
Today's proceedings have concluded. The host will now terminate the meeting.